Hi guys, welcome back to my channel. My name is Kseniya. I make videos for people who are going through the family immigration process. In today's video, I wanted to give an update on the form I-131F. At the end of August of 2024, just a couple of days after the I-131F Keeping Families Together program started, it was temporarily paused. So it's not canceled, it is paused due to litigation over the validity and the legitimacy of this program. Because this program is paused, USCIS had to make an announcement that they will not be able to make any decisions on these cases. However, it doesn't mean that they're not accepting any more of these applications. In fact, they are continuing to accept the I-131F applications. Of course, you must also pay the associated fee for this. If this program discontinues, obviously USCIS will not be able to refund you these fees. So that is a risk that you would have to take. However, I did watch quite a few live streams from different immigration lawyers who have had experiences with similar programs in the past, and they're all saying that this should not deter you from submitting your I-131F applications to get your spot in line in case this program does go back in effect. So they are continuing to accept the applications, and that they are continuing to schedule the biometrics appointments for these applications as well. So aside from this update, I also wanted to address some frequently asked questions about this particular application that were answered during their webinar, and some of the answers to those questions have not yet been posted on their Q&A page about this program. This is a super important note, and I cannot really find it on their site yet. I will post it in the background if I do. But this entire process is all online, and they made it very clear that you should not be expecting any paper receipts. So for example, your receipt notice will be given to you online after filing this application in the document section. Same applies to the I-797 approval notice. If your application is approved, it will only be posted online in your USCIS account. This entire process is fully online, and you should not be sending them anything by mail, and they will not be sending you anything by mail either. This also refers to their requests for evidence. They also made it abundantly clear that if they are missing information from you, or they need more information from you, and they issue you a request for evidence, you must respond to that request for evidence also online. This process is fully online. Your I-797 approval notice will include a copy of your I-94 arrival record, which will serve as your new parole in place, which means you were admitted in the place without having to leave the country. When filling out the I-131F application, each person must have their own USCIS account with their own unique email, so that USCIS can provide you with unique updates for your case. Next, you can file this application even if your US citizen spouse or step-parent is no longer living. If you meet all of the other eligibility criteria for this program, but you only continue to be eligible if you have not remarried. Okay, the next thing they wanted to make very clear: you cannot travel once you get approved for this form. So once your I-131F is approved, doesn't serve as advanced parole, and you cannot travel overseas. And they also say that even if you do apply for advanced parole, for example, you decide to go ahead and file the forms I-130, I-485, etc., and the advanced parole application, you should not be traveling. So there really is no point in applying for advanced parole with your further adjustment of status case, because you can always be retained at the border and questioned, and you may trigger a permanent ban. So don't travel until your process is complete, which means until you get your green card. Next, if you choose to apply for employment authorization with this form, not with adjustment of status, but with this application after your I-131F is approved, your I-765 application type will be C11, and you will be able to file this application online. You cannot file the I-765 application at the same time. You must first wait for your I-131F approval. If you are applying for employment authorization later with your adjustment of status application, your category for that case will be C9, just like for all other adjustment of status applicants. Next, there was a question about the age eligibility for stepchildren. If you are a stepchild of a US citizen and you are already 21 years old, can you still file this application? As long as you were under 21 as of June 17th, 2024, and you were unmarried and you had a qualifying step-parent, stepchild relationship with your US citizen step-parent, which means when your parents married, you were under the age of 18. There was another question about the I-130 form. If you are eventually trying to file for adjustment of status, will you have to file the I-130 petition? And the answer was absolutely yes, you will still have to file the I-130 petition to prove the basis of eligibility. But they did say that you do not have to wait to file the I-130 petition. These two applications, I-130 and I-131F, are not dependent on each other, so you can still go ahead and file the form I-130, and according to USCIS, technically the I-130 approval doesn't really expire, so it should not prevent you from filing these two forms at the same time. The next question, which was not directly asked in the live stream, but it was implied through their answers and eligibility criteria. Will the 10-year mark keep shifting every year? So for example, in 2024, you should have been present in the US as of or before June 17th, 2014. So the question was naturally, next year in 2025, will that 10-year requirement shift to 2015, for example? I hope you're keeping up with me. But the general answer, based on all the other answers that they were providing, is no. They are only making this program eligible for people who, as of this year, have been here on or before June 17th, 2014. So if this program comes back and continues in 2025, 2026, this requirement will not keep shifting up. Eventually, maybe they will change it, but as of now, they do not have plans to expand it. They did say that all felony offenses will be disqualifying under this process. If you have a criminal charge that is not a felony, they do say that it will potentially disqualify you unless you can present other mitigating factors to show that you are still qualified for this process. And they also said that if you have any pending charges, your I-131F application will be automatically denied. Misdemeanors, such as minor traffic offenses, like we said, will not make you ineligible, but you should still provide the explanation and disclose it. They did say that when uploading any of your evidence online in the evidence section, to make sure that the file name has a very specific name on it so that the file name, the documents that you are uploading from your computer do not look like mumbo jumbo. So for example, if you are uploading a document that is a scanned copy of your marriage certificate, make sure that the file name when you're actually uploading it says marriage certificate. The next question was about medical or vaccination requirements. There will be no medical requirements and no vaccination requirements for this step of the process, but eventually, if you do choose to file for adjustment of status, you must complete a medical exam and you must present them with all required vaccinations. So the final couple of questions have to do with your previously denied adjustment of status applications. So if your adjustment of status application was previously denied because you could not prove your legal entry to the United States, once your I-131F form is approved, USCIS will not reopen the prior denied case. If your I-131F is approved, that will satisfy the requirement for legal entry to the United States for your newly filed I-485 application. So you will have to file a new one. And the final note is for those of you who currently have provisional waivers in place, so pending I-601A applications, they did say that these two applications are not dependent on each other, so you can go ahead and file I-131F even if you have 601A pending. And if your I-601A is approved and if this program is still not active, then you can go ahead and continue the 601A waiver. If this I-131F is resumed and you have a 601A, and in the case that your I-131F is approved, you can go ahead and file for adjustment of status, but keep in mind that in that case, you will receive a denial letter for I-601A because obviously you will no longer be eligible for that and they will not be refunding any fees. I will update you guys if this program comes back, because typically the way that the justice system works in the US, it's not that quick. I do foresee this pause being extended for quite some time. I don't think personally that this program will be resumed in 14 days. I think that this pause will be extended longer and longer and longer, possibly even after the election season. That's just my personal prediction. I hope that you found this video useful. Subscribe to this channel to stay updated, and I hope to see you guys in my next video. Bye!